Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? From work authorization revocation to TPS expiration, the Trump administration is rapidly altering the landscape of immigration law, and employers are struggling to keep up and remain compliant. On this episode of We Get Work, we unpack the latest regulatory changes facing employers with non-U.S. citizen workers and ongoing legal proceedings that may present more compliance challenges. Our hosts today are Michael Nefak, Office Managing Principal, and Marissa Prianti, Associate, respectively, in the Washington, D.C. region and White Plains offices of Jackson Lewis. Michael and Marissa, the question on everyone's mind today is: what proactive steps can employers take to address evolving immigration regulations, and how will it impact my business?
Thanks, Alicia. I appreciate that intro. Marissa, thanks for taking some time. We're going to be talking about TPS and parolees and the recent actions by the Trump administration that have limited the availability of TPS and parolee work authorization over the last several months. It's created a lot of confusion out there for employers. We get calls regularly about, I've got individuals who are work authorized, they're from certain countries, they're under the TPS. Are they still authorized to work? And so it'll be helpful, I think, to talk through first by starting with an overview of the primary countries that are covered by TPS and when those statuses are going to expire. Marissa, can you take us through a little bit about where things stand?
Sure, thank you. The primary countries of concern with temporary protected status are going to be Haiti, Venezuela, Nicaragua, Honduras, and Nepal. To start with Haiti, pursuant to pending federal litigation, the program is currently extended till February 3rd, 2026. This means that individuals have the temporary protected status and work authorization until that date. Again, could change depending upon the outcome of litigation, but that's the status as of now. With regard to Venezuela, there were two different designations, one in 2021 and one in 2023. The 2023 designation is completely terminated. For those individuals, they no longer have the temporary protected status or work authorization. For individuals who registered under the 2021 designation, their temporary protected status and their work authorization will expire September 10th. There has been a letter circulating among many immigration attorneys arguing that the program will be extended until March due to some regulatory arguments. We are advising clients that they should not employ individuals with Venezuela TPS work authorizations beyond September 10th, 2025. We believe that the Department of Homeland Security would likely say that these individuals were not work authorized beyond that date in the event of an I-9 investigation. With regard to Nicaragua and Honduras, and Nepal as well, they were previously going to be extended until November 18th, 2025, pursuant to pending litigation as a result of a recent Ninth Circuit decision. Unfortunately for Nicaragua and Honduras, the expiration dates have been put back to September 8th, 2025, and Nepal now expired on August 20th, 2025. So that is a brief overview of where things stand with the TPS countries. Last thing I want to mention is that we E-Verify employers have the capacity to run these quote unquote status change reports from their E-Verify accounts. What we are seeing is that a lot of individuals who are covered under a humanitarian parole program for Cuba, Haiti, Nicaragua, and Venezuela, that program is entirely terminated, are showing up having their work authorizations revoked on these status reports. So it's very important that employers who participate in E-Verify run these reports, because DHS will not view not running the report as, an excuse for continuing to employ these individuals pursuant to those work authorizations. There's been a lot of confusion around this humanitarian parole program, so I'll kick it over to Michael to discuss that further.
Yeah, so the humanitarian parole program that really has been an issue is the CHNV program. That's Cuban, Haitians, Venezuelans, Nicaraguans. As Marissa said, it was terminated by the Trump administration These are, hundreds of thousands of individuals fall within these. These were individuals that were paroled into the U.S. By the Biden administration. They got 2 years work authorization. Those work authorizations would be designated by C-11 on the EAD. And when this program was paroled, there was immediate litigation that ran its course, and the Supreme Court finally said that the administration can end that program. We were getting questions from employers of, well, how do I know that my employees fall within that program or not? Should I go back? Should I start looking at and doing an audit to find C-11s? Remember, also, some employers don't keep copies of the documents. It was not an easy process at all. And really, employers were just hamstrung on what to do. The administration then started to issue letters to individuals, but not to employers. And we were getting questions from employers saying, I'm being told by an employee, hey, I just received this letter. It says I don't have work authorization. What should I do? And our advice is, and continues to be, if you receive notification or are on notice that your employee, with even if it looks like a valid document, is no longer authorized to work, you have to take steps to re-verify the employee, see if they have some other work authorization, and if not, you're going to have to terminate them. That's the steps you should take. Then the administration started to issue, for E-Verify employers, they started issuing case status updates that were indicating that certain individuals no longer had work authorization. If you were an E-Verify employer and your employee had been verified or onboarded using a C-11 EAD that then was being revoked, you could receive notification. The government most recently said that they're no longer going to do those individual ones, and instead employers need to run case reports, and they should run them periodically. And we were getting questions, well, how often do I need to run those reports? And there's really no set date on how often to run those reports, because when you run those reports, you will now see a list of anybody who was E-Verified using one of the work authorization documents that may have been revoked. But gradually, the government has put guidance online, and we're seeing that they're updating the information every, say, 2 or 3 weeks. We've seen several updates from the government, and the best course of action is to, probably weekly run those reports, see if there's any names that have been added. But certainly within that 2 to 3 week period, it makes sense for employers to run an update. For those that are using third-party vendors, you don't have direct access, and you'll have to rely on your vendor to update the system and to give you those reports. Most vendors are doing this, and if you work with your vendor, you can get that information through them. But similar to when you were getting notifications individually from an employee saying, hey, I received this letter, if you're receiving that update through E-Verify, indicating that the employee their work authorization is no longer valid, you need to make sure, and the reports will include the EAD number. You need to make sure that it's the same number, because there are instances where somebody may have been verified initially with a C-11 EAD that's been revoked, but since that time, they may have brought you another EAD. They may have applied for asylum or some other status that has not been revoked. So you need to make sure when you get that information that you're matching it up. But if it matches and it looks, and the E-Verify notices that this work authorization was revoked, you need to be proactive and re-verify that employee. And if they don't have something that's valid, a new EAD or some other list, A or C document that they can show that they're work authorized, you're going to have to terminate them. And this keeps evolving. A lot of these time deadlines are based on litigation and preliminary injunctions that were filed. So, it's important to stay tuned and to see where all of this litigation goes, both on this for these CHNV, other parole statuses, as well as the TPS. Marissa, anything else that is important for employers to understand?
Yeah, I would just say, as Michael said, we get a ton of questions from employers. I get them almost every day. It is really important to reach out to immigration counsel because the answer is not always obvious when it comes to these work authorization documents. And the last thing you want to do is inadvertently terminate somebody who is in fact work authorized and potentially open yourself up to a discrimination claim. It can be just as bad, if not worse, than continuing to employ somebody who you think is work authorized who's actually not. So again, just very important to double check with counsel.
Absolutely. Thanks, everybody. I think that covers what we were going to do on this podcast.
Thank you very much for joining.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.